first really interesting part of this report concerns conflict of interest. In a nutshell, this is when you hold two different interests. Often when you're a public office bearer, one of them is private, like you own a business. The other one is public, you have a public position. And those two interests are in conflict. You can't execute them both at the same time without one impacting on the other. Now, the ATM, which was the party that brought this complaint to the public protector, as well as the DA, effectively said, look, you can't have a president who on the one hand owns a massive financial interest in a farm which is doing trade to the tune of millions of rands on the one hand, and be president at the same time on the other hand, because those two things may compete with each other, and you may be able to get undue benefits from the one because of your position in the other, or you may wield your position to get the undue benefits. And so there's just an uneasy tension between, on the one hand, owning a business, and on the other hand, being a president at the same time. Now, South Africa's laws do consider this. So there is the Constitution, and there is Section 96 of the Constitution, which really covers the question of conflict of interest. There's also legislation in terms of the Executive Members Ethics Act, the Public Protectors Act, and then there's a lot of case law that has emerged, especially around the question of presidential conflicts of interest. So the public protector had to have regard to the legal, constitutional, legislative framework, and then determine whether in these specific facts, with this specific business, this president, and this office, there was actually a conflict of interest. And effectively, the big thing she finds is that there was no conflict. Now, this is a little bit of a strange finding, if you ask me. And that's because when it comes to presidents, conflict of interest becomes heightened because of the importance of the presidential office. So this is not just any old governmental employee. This is the president. And the higher your office, the higher your responsibility to preserve the integrity of that office and to ensure that that office isn't tainted by other personal financial interests that may influence your discharge of your duties in that office. Now, the Constitutional Court in the Nkandla Judgment, you'll remember President Jacob Zuma kind of was seen to have improperly benefited, getting a private benefit from his public office at Nkandla. And in that Constitutional Court judgment, there was an interesting line in paragraph 9, which I'd like to read. It says, "The potential conflict lies here," and this is in relation to presidents' conflicts of interest. "On the one hand," says Justice Mogoeng, writing for the full court, "the president has the duty to ensure that state resources are used only for the advancement of state interests." You can only use state resources for the advancement of state interests, not private interests, not business interests. So if you have access to state resources, a conflict arises where those resources are deployed for any other interest other than state interests. It continues, "On the other hand, there is a real risk of him closing an eye to possible wastage," that being the president, "if he is likely to derive a personal benefit from indifference." Let's just take a step back there because that's to do with the Nkandla facts. But basically, a president may overlook certain benefits that they get if they believe that they're able to derive benefits from some kind of conflict of interest. That conflict may cause them to overlook the way the conflict of interest is happening. That's the whole point of conflict of interest. It creates a problem in your lens because your own bias and your own interest causes you not to see certain things. And finally, the court then says, to find oneself on the wrong side of Section 96 of the Constitution, which is the relevant section, all that needs to be proven is a risk. And here's the kicker. It does not even have to materialize, that being the risk. So when it comes to a president, what the court is saying is that you are in a conflict of interest if there is even a risk that there is a confluence between your private interests and your public duties. Not that you did anything, just that you created a risk that something may be done. And that risk doesn't have to materialize. The risk itself is the conflict. And you can see why that matters, because when you're the president, when you have national secrets at your disposal, when you can decide whether the country goes to war or not, whether you take the main economic decisions, not for your family, but for the entire country, whether you wield, when you wield the disproportionate amount of power in government, anything you do that exposes you to a potential private risk is itself a conflict. So when the public protector turns around and says that she can't find any evidence that there was a conflict between President Ramaphosa's private interests through the Phala Phala Farm and his public duties, it's difficult to see how she arrived at that conclusion based on the mere existence of a risk of conflict. I would argue this risk actually materialized in the way that the president reported this to his presidential protection services and said, please look into that. At that very moment, a conflict arose. Was the president who called in his VIP protection service? Yeah, we all know VIP protection services always follow the law, right? Hello, Deputy President Paul Mashatile. When he called in General Wally Rhoode, this is his protection service person, and he said he was in Ethiopia at the time, in Addis Ababa. And he said, I hear that there's been a break-in at my farm. Can you look into this? Rhoode was there because he's the president. He told him to look into it. Was he telling him to look into it to protect a public resource or a private interest? At that very moment, not only in my view was there a conflict that was at risk, but the conflict materialized, which far exceeds the test that was set in the Nkandla Judgment in terms of conflict of interest. So I think that the public protector's refusal to appreciate the existence of the risk, you don't need overt evidence where a president calls someone and says, here, I've got two conflicting interests. I want to use the one interest to help the other. You're never going to find evidence like that. What you need to see is there the existence of two separate risks that are at risk of conflicting to the objective observer. How the public protector didn't see that beats and baffles me. But you can go into the report and see for yourself what she says. I think one of the mistakes in the report is to look at the president's actions in relation to the theft, not the president's mere holding of this financial interest and his admittedly arm's length, but actual participation in some of the activities of the farm as seen in the admitted facts in the report. So conflict of interest, I'm not so sure the report is going to stand up to legal scrutiny on that. I think if wise advocates run similar arguments to the arguments that were run in the Nkandla case, talking about pure exposure to risk, we're going to see the findings at least impugned, if not challenged. You know, the Nkandla case is actually interesting. I see a lot of people saying, yeah, but you can't compare Nkandla and Phala Phala. And of course, there are relevant differences there. But there are actually important similarities that I think have been overlooked. Firstly, they both involve the president in their private and public capacities at the time. They both involve public protector's reports and the public protector inquiring into the president. But thirdly, they also involve the police and the way that the police and private protection units around presidents, or the police in the case of Nkandla, create protection around the president that can cause a conflict between private and public protection. You'll recall in the Nkandla case, the police decided, no, we need to build these security upgrades at Nkandla because we need to secure the president. But then it was like, but we're securing his private residence, so which one are we securing? Here we also have a police official who goes and does an investigation, which he's not authorized to do under the auspices of the president, and you have the public protector inquiring into that. So I actually think mutatis mutandis, as they say in the law, all the other facts taken into account that are different, there are many interesting parallels between Nkandla and Phala Phala. But let's get into the next question, which is about paid work, because I think there's a lot of interesting stuff to be said here too. Because Section 96 of the Constitution also has this prohibition against members of the executive, like the president, undertaking paid work. And you can understand, like, you can't be a president and be moonlighting somewhere and working, just doing whatever you want, because clearly not only will your attention be divided, but your interests will also be divided. There would be a question about who your loyalty was to, the one paying you on the side or the presidential salary. So you can't do paid work. Now, there's a fascinating legal question here as to whether the president was engaged in paid work or not. And there are actually diverging views in the Public Protector's report versus the Ngobo panel report, which I think we need to accentuate. See, the Public Protector took a very narrow view of what paid work is. So President Ramaphosa owns this farm. The farm is a closed corporation. He is the sole member. So he's the sole owner of this farm. But he doesn't engage in day-to-day operations every single day from 9 to 5, right? So he's not on the farm clearly every day looking after his buffalo. By the way, the Public Protector's report includes the names of the buffalo that was supposedly sold to Mr. Hazim, which are quite hilarious. So some of the names are Kimberly. We've got Layla as well. And Layla, apparently one of Layla's descendants, because they also have like the lineages. There was another descendant called Whitey, the buffalo. Shout out to Whitey. I think there's one called like Dronker or something. Shout out to Dronker, the buffalo. So this episode is dedicated to Dronker, Whitey, Layla, Kimberly, and all their brethren. Moment of silence. Anyway, so hey, you just read the names of the buffalo people. It's literally hilarious. So the Public Protector, basically, back to paid work, says, okay, look, there's a difference between being a worker or being someone who's paid to do something and being an owner of an asset. And the Public Protector says, effectively, yes, the president owns the farm, but he doesn't work on the farm. And the prohibition is against paid work. He's not getting paid to work on the farm. He just owns it. So he kind of has a passive income in the farm, but he's not actually doing paid work. That's the Public Protector's argument. It's an interesting one. It's quite a constrictive interpretation of what paid work means. Justice Ngobo looked at exactly the same question and came to this conclusion. In paragraph 191 of his report, he says, in our view, the provisions of section 96(2)(a), which is the paid work provision, puts a member of cabinet to a choice. The choice is, you either remain in business and do not become a member of cabinet, or you become a member of cabinet and relinquish your business interest during your membership of cabinet. So his understanding of paid work is much wider than just, oh, you're an employee who gets a salary from some place. If you are doing some active, or if you retain some active involvement and you're getting a financial gratification, maybe even as an owner or a controlling owner, we can think of that as paid work. Yes, you may intervene sporadically. Maybe it's not 9 to 5 every day, but you intervene. People call you. Can you do this? Kimberly's feeling sick today. Should we buy some food for Kimberly? You say we can buy some. So basically, receiving a gratification while performing effort can be seen as paid work, even if you're just a controlling shareholder. So we have a dispute here, which is ultimately going to have to be resolved by the courts, which is, do we define paid work really narrowly to be like you're an official employee? Or is the purpose of that section to prevent people from getting financial gratification via where they have a controlling influence? Now, Again, I side with Ngobo on this one because, quite frankly, let's look at the absurdity of the Public Protector's report. What that means is, if you're the president of the country and you're a farm worker at Phala Phala, then you've contravened the Constitution. As a farm worker, you clean around the kraals and you help with the feeding of the cattle. As a lowly farm worker, you can't do that constitutionally, according to the Public Protector. But if you own the farm and you can call people and tell them where to put the money on the farm and where the money should go, and you own the land on the farm through a trust, that's okay. How can the farm worker have more of a conflict of interest than the farm owner? So we need a more expansive appreciation of paid work. If that expansive appreciation of paid work is too expansive, then still you fall into the crosshairs of the conflict of interest provisions outside the paid work provisions. And there's simply no way around having one private interest and another public interest. And the fact of the matter is the Public Protector used all sorts of legal legerdemain or acrobatics or tactics to avoid a very obvious truth, which is that the president has a deep private interest on the one hand, a deep public interest on the other, and those two things clashed on the day of that robbery and in the weeks following that robbery, when he tried not only to suppress it, or at least not tell the public, but also to get to the bottom of it via his protection service.